Good morning, afternoon, or evening. I am Stephanie Joy with All Things Social Security and the attorney at Joy Disability. You're about to see what should be a question and answer format type of chat from our live session on a particular topic that we find that a lot of people keep asking about. So I'm sharing it here. If there are pieces that could have been added that weren't added during the live, because there's a kind of a fast-paced Q&A that we do every Wednesday at 1 p.m. You might just find that I added something to the end of it to give it a little more clarity and a little more details for those that are interested in that particular topic. So check to see if that's at the end. Otherwise, enjoy the video. Bye-bye. How far back can an adjudicator go on medical records on initial claim? Well, they can go back as far back as they want. They tend to like to limit it to 2 years or less. I would say generally, some of them say 1 year, and they can never find you disabled based on that information. It has to be where it's continued to now. So that's why you have to be aggressively treating, following at the very least for everything. And because not everything has a treatment and not everything is curable. And we all know that. But for me, if there's something really pivotal and it happened 8 years ago, before they stopped working and they went back to work. Let's say they had a back surgery and they were able to go back to work. And then 4 years later, I see they need physical therapy on the back, while they're still working, so they're not disabled yet, but they're addressing these like growing impairments. And then I see that I might get that stuff because if their back problem is now what's considered one of the big problems, that I think would be good historical perspective, specifically under those circumstances. If they had a surgery 20 years ago, not so much, particularly if they just started, treating now for it. But it should be as in a roundabout way anyway. So even if you're not going to get the records from 20 years ago, which you probably can't get anyway, the fact that you had the surgery 20 years ago should be evident in the records today. We're just talking if it was surgery, but because you give the history to your doctors today and you say, I had a lumbar surgery in 2005 and I had this and I had that knee replacement, so there's reference to it in there, and that may be sufficient for the historical perspective. And the reason why I like some historical perspective sometimes, even though I know it can't be the proof of being disabled today, because I like them to see that this has been growing. This person didn't leave work when she had the first aches and pains. She got physical therapy. He or she got, had the surgery, did everything right, went back to work. You could see in the doctor's notes there were still complaints about pain, but she still went back to work. Like, wasn't the kind of person that just threw in the towel. And I do that for a psychological reason. I think it's nice to see the work ethic of the person. If it's there to be seen, doesn't mean that people that didn't do that don't have work ethic. It's just that there's no evidence to supply on paper. So that's another reason why it can be good to have that stuff in there. Old Grizz is in the house. I can't believe you're here, my friend. Hello, Stephanie, checking in from Montana. Heart attack can't keep me down. Thanks for you too. Oh my God, we were praying for you there. Old Grizz. You and your better half. What are we going to do with you? And yes, same day. That's how we do it, guys. The information went up to the adjudicator. Even if it's not the impairment that the person is prevented from all work from, if there's an exacerbation such as that, we just get it in and get all the information. Here's the hospital for them to order the records and stuff because they have their little HIPMERs and all this other stuff. But yeah, that's why. And some clients are really good about sending us the information. Usually sometimes it's a spouse. If someone's not able to send it in themselves because they are medically severely troubled at the time, but sending those records in, not the records, sorry, the fact that there was a visit to this particular thing or this MRI or this hospitalization the other day. Those are things, those objective things or things of magnitude like this are things I want that adjudicator to know about. And I immediately notify them of the occurrence and where everything can be had, even if we don't have any of the records yet, because they're going to be ordering them and we will be ordering them if we have to. But we're not supposed to duplicate, so give them a chance to order it. Again, it really, depending on a case, depends on whether such a thing as this would be kicking out old jobs. like this particular impairment, assuming it has a 12-month durational proof. Everyone's requirements of proving disabled, they have different laws that apply to them. So an older person, such as myself, this is going back to the grids. We don't have to prove we can't do all 12,000 jobs. We have to prove we can't do the one we had if we had one in the last 5 years. That was SGA. And if we did, if we can't do it, could we transfer the skills to an easier sedentary job? Or, for the older people, we only have to prove that we can't do a heavier job, medium or above. So it is true that cardiac things can lend themselves to that, which is helpful, particularly if we don't have like severe back issues that would very much lend itself to that. So the cardiac it's not going to really reduce a light or sedentary, but it can reduce you from being able to lift 50 pounds multiple times a day, right? Potentially.
Good morning, afternoon, or evening. Your video is about to start. I wanted to remind you of our newer Wednesday, 1 p.m. live stream Q&A on all things Social Security. Visitors are welcome to post a question in the chat, and I'll do my best to answer it. It's on a first come, first serve basis, so please get there on time. Otherwise, if you care to be a member and get some different kinds of perks, feel free to click the join button below or just click it to learn about them. Anyway, I hope to see you Wednesday. If not, enjoy the video. Bye now. Hey, so how far back should you go getting medical records when you have an SSD or an SSI claim? This is so reasonable minds can definitely differ, and I think every case is specific to itself. I mean, I do think as a general rule, if someone comes to me and they stopped working as of 2023, but they had growing problems since 2019, or even just started seeing the doctor that they now treat for problems since say 2019, I'm going to, in my application, put down when they started seeing that doctor under the start date, because that's what it asks for. And that could be 2015. And while the SSA will probably not go back more than, sometimes they say a year, sometimes 2. It's not really, I don't think it's carved in stone. But if it is something that I know there was progression showing up, like she was treating, let's say it was aches and pains in joints, since 2019, maybe it was diagnoses, rheumatoid arthritis in 2021. She keeps working through it. Now it's 2023 and she can't work anymore. It's just too much, too painful, too debilitating, ruining the rest of her hours awake. And maybe she's not doing as good of a job either and just getting reprimands. But I am probably going to go back to, like in a situation like that, I'm going to go back and get at least back to 2019, when she said she started treating for it, or when the problem arose, because it will show the progression, it'll show the complaints, it'll show presumably the complaints getting worse. It's going to show all the conservative treatments that were tried, and failed, obviously, because the person's getting worse. Although who knows, I should be saying, without the treatment, maybe the progression would have been faster. I can't say one way or another, but I would be going back to 2019. If it is, let's say you have a bad back now and you had a surgery that was 14 years ago, I don't know that you have to get the surgery record. It's going to be noted in current records that you had the surgery. I mean, unless you're not telling your doctors your history properly, which you really need to do. If it wasn't showing up, maybe I would get something, but you're probably not going to be able to go back that far. They probably won't have them unless you're still treating with that same entity. Now, if if there was so much intervening stuff, like the surgery way back then, now you're still working, but then you're doing PT on and off for you know, the last 6, 7, 8 years before you. I'm the type that probably would want to get them. I would. Um, they're not earth-shatteringly critical, but I am the type of lawyer that wants to get every single crumb because if one crumb's lacking over here and it doesn't exist, I get this other one that might help buffer it. I just think the more crumbs we have, the more likely we are to get to the full cake. It's what I always say. And I'm not even a baker. I don't know why I talk like that. But that's how I was looking at it, like every crumb. Um, so sometimes I do want all that old stuff. It's going to depend. Like if they're going to charge the client an arm and a leg, now granted, we use the high-tech HIPAA rules. We offer our clients those kind of releases so that they can, have access to their records that way. Um, and that makes it much more affordable. I have, by the way, videos on that. If you're not using the high tech and you're paying for medical records, that's probably a mistake on your part and it's costing you. So anyway, take a look at that. It's under HIPAA probably, playlist maybe. But um, I'd say far more than not, I go further back than the 2 years prior to the date of disability. Um, I don't do it for innocuous things like if the person does not have a gynecological problem or anything related hormonally, and I'm not going to go back 20 years and get, gyno reports for someone with a bad back. Um, I'm just not because, it's completely in a different area and there were no issues. Um, if there was a gynecological problem, let's say endometrial type of things. Obviously, that's different. That could be a growing thing if that is now a problem today. But generally speaking, I'm not going to get that kind of preventive care to show that everything's cool 10 years ago because that's not, A, that doesn't help the case. Um, and it would just be wasteful of someone's time who has to read it, which would be the adjudicator and an ALJ. And I don't think that's necessarily wise. You want them to focus on the important stuff. So when you think about how far back you're going to go, because like I said, the SSA is going to make their decision in order, however far back they deem fit, which again will probably be only a year or two. But although again, I see them go further sometimes. God, now I'm hem-hawing, right? Let's say you say you've been treating with that person for 5 years, you've only been disabled for one alleged onset date, but you had a knee surgery 3 years ago. And usually when we have knee surgeries, our knees are never 100% after that. We might be able to walk around without a cane, don't get me wrong, but usually it means maybe we can't run marathons anymore. So something arduous is going to maybe be out of the question. Maybe not. But I've seen them go and order the whole kit and caboodle if it's just a few extra years and you've indicated that you had a surgery in 2021 or 2020. They might not go way, way back though. For the old one. But again, it's going to be noted in the record as part of your history in your medical record that you had that surgery back. So don't feel compelled because the actual hospital records are just a snapshot. If you already know there's a surgery, it doesn't really matter, right? Um, so every kind of impairment and who was your treating provider and what they did for you is gonna point to whether or not it should go a little further back than a year or two. And if it was limited at that time, even if it precedes your alleged onset date. If it, they, like I said, they go 2 years before your alleged onset date. But if you have a bad problem today that you've been treating for leading up to, I'd probably get it all the way back to when I started treating for it. That's what I would do. And you're not necessarily going to be able to get the SSA to do it. So that's when you have to like be proactive and get your own records. There's nothing to say you can't do that. And if you really want to have a stronger case, maybe you want to do that. If you're pro se, you're going to have to do that yourself. Like I said, the SSA is not going to do it for you because they don't want them. But sometimes it's educational for them. And it's something that's going to go to an ALJ too. And then you're going to be in front of the ALJ. And you might be talking about how for the last 8 years before you stopped working, you were doing, a lot of these conservative therapies and all that he would not have known about, but for the records. And now you're talking about it, but our talk at a hearing doesn't really count as a medical record. So for instances like that. So it's fact specific. It's a little nitpicky. Kind of have to look at the logic behind it. And that'll usually lead you, I think, to the proper, most diligent way to go for what could be the strongest case. Remember, sometimes we get evidence that isn't going to end up helping at all, but you don't necessarily know that till you have it in hand. And you might not see it. It might be something the judge can recognize that you might not. I see people blow off even telling me about certain doctors because they didn't think it was relevant. And I'm like, tisk, you should have told me. If for no other reason, sometimes when you're treating with that person for an innocuous thing, but sometimes there's good commentary that you made that you don't remember. Even though they're treating you for your big toe, you talked about your back. They're not treating you for your back, but they were diligent and recorded it. So anywhere we can get diligent statements like that, even if it's from a person that wasn't treating you for that, but is a medical professional who was treating you for other, it shows that you're complaining about it. And that's always somewhat relevant, I think, to a judge, because it shows that you indeed were complaining about it. Even before you're still working, working for the man, plugging away, despite the pain, but there's evidence of the pain right there. It goes towards your character, maybe your work motivation, your work, the way you think about work. And it might point to someone who's not one that would have just stopped for no reason. So there's a lot of different nuances in there. Okay. All right. I hope that responds to that one question someone gave about, I think it was at last week's live Q&A. So I wanted to go into it a little bit further. All right. Thanks, guys, and have a great day. Bye.